North American Title, your closing and title professionals presents Ways to Hold Title to a Property. There are many kinds of homes and many kinds of home buyers, including single owners, spouses, partners, and even whole families. There are also many ways to hold title to a home, and your decision on how to own your home has ramifications for items such as property taxes, income taxes, how property can be transferred, and how property has exposure to claims by a creditor. It also has significant implications on how a title is passed after the death of one or more of the owners. You see, laws governing the ownership of real property, such as land or a house, vary greatly from state to state. So we can give you a general overview of a few ways to hold or vest title and provide general educational information on this topic. But we are a title company and not an attorney or law firm, so we cannot give you specific legal advice. So you will still need to talk to a real estate attorney who is licensed to practice law in the state where property is located to determine the best way to hold title in your individual situation. In some cases, it may be in your interest to consult a tax advisor as well. If you are a single person, you may hold title individually in your own name. Some common law states characterize such individual ownership as tenancy and severalty, while other community property states refer to this form of ownership as sole and separate property. Although the terminology varies according to state law, in each case, property is owned by a single individual. Please note that when we talk about tenancy and holding title, it is not the same thing as being a tenant under a lease or other agreement for rental of real property. There are several ways to hold title to property as a married couple. Tenancy by entirety is a form of joint ownership by two spouses in certain states where both have the right to the entire property while living. When one spouse dies, however, the title passes automatically to the other by reason of that spouse's right of survivorship. In contrast, other states recognize community property, a form of ownership that flows from the Spanish legal system and is recognized in California, Arizona, New Mexico, Texas, Idaho, Washington, and Louisiana. In community property states, both spouses have equal rights to ownership and control of the property while living, as in states that recognize tenancy by entirety. However, upon the death of one spouse, the disposition of title to the property may be different. While some community property states recognize a right of survivorship, others do not. In those states, the deceased spouse's interest in the property may pass to that spouse's children or other legal heirs. In either case, the rights of the spouses to the property are determined by specific state laws. There are other ways to hold title if you have two or more buyers of a property. With tenancy in common, each owner shares equal rights to use the property, even if they own different percentage interest in it. Each individual tenant in common may sell or will his or her interests without agreement by the co-tenants. No right of survivorship exists, and when a co-tenant dies, the estate must be probated to transfer the interest. Joint tenancy is similar, but the interest must be equal, and each tenant has a right of survivorship. Upon death of a tenant, the interest passes automatically to the survivor. Another method of holding title to real property is as trustee of a trust, where legal title to property is transferred to one or more trustees who manage it for the benefit of those named in the trust as beneficiaries. Finally, although it is not common, a residential real property title may be vested in a legal entity such as a corporation, partnership, or limited liability company. So you can see that holding title to your new home may be simple, or not. Remember, this video is only a short overview of several ways to hold title that is provided solely for general educational and informational purposes. We as escrow and title professionals cannot and do not provide legal advice or recommend what will work best for your individual situation. You must make that decision based upon your own specific facts and circumstances, including, among other things, the state in which your property is located. Be sure to discuss the issue with a real estate attorney and, if appropriate, a tax expert who is qualified to help you make this important decision. Good luck!